Welcome to our 2025 People-to-People Group Employment Law Update. I'm Mary Savova, Acting Branch Manager here in our Melbourne office, and wanted to talk to you about some of the employment law challenges across Australia and New Zealand in 2025. Today, we are joined by Jonathan Mamaril, Director and Head of Employment Law at South Geldard Lawyers, and Gareth Abdinor, employment lawyer and workplace expert at Abdinor Employment Law, to explore the major employment law challenges shaping Australia and New Zealand in 2025. What's changing for employers in New Zealand and Australia? Are you prepared for tougher expectations, and what will reshape workforces by 2026? But first, let's kick things off and look at what's been happening in the last 12 months. In 2024 and continuing into 2025, Australia and New Zealand are seeing significant legal reforms impacting the sales and employment landscape, particularly in areas of worker rights and employment contracts. Among the key changes is the right to disconnect, giving employees the clear entitlement to ignore work-related communication outside of working hours. The right aims to support work-life balance and prevent burnout, particularly from off-hours client and customer interactions. Sexual harassment laws have also been strengthened. There's now a clear obligation on employers to take proactive steps, including financial penalties and oversight from regulatory bodies like the Fair Work Ombudsman and the Sex Discrimination Commissioner. Employers are encouraged, or in some cases required, to implement training and policy reforms to create safer, more respectful workplaces. Additionally, there is a shift around fixed-term contracts, which are now limited to a maximum of 2 years in most cases. This change is designed to reduce job insecurity, particularly for employees in roles that previously relied on rolling fixed-term contracts. And when it comes to psychosocial risks and hazards, employers must now actively assess and mitigate issues like workplace bullying, poor change management, or unclear role expectations, highlighting a more holistic approach to employee wellbeing. Finally, wage theft is under serious scrutiny as we head into 2025. HR and payroll teams must be diligent, as underpayment cases can now attract criminal penalties, including up to 10 years of jail time. Companies may also face financial benefits as steep as $1.5 million or 3 times the underpaid amount. These changes signal a firm commitment to fair pay, transparency, and stronger employer accountability. Together, these legal updates reflect a broader cultural and legislative push towards fairness, safety, and long-term stability in the workplace. For businesses in sales and beyond, staying compliant isn't about avoiding penalties. It's about building trust with employees and creating a modern, supportive work environment that can attract and retain top talent. All the insights we've just shared and the conversations we're about to have are drawn directly from our 2025 Employment and Safety Salary Trends Report. This comprehensive report is built off thousands of survey responses from job seekers and employers across Australia, New Zealand, and the UK, looking at latest workplace hiring and job seeker trends. If you'd like a deep dive into the salaries, benefits, or workplace trends across your market, you can request a copy by scanning the QR code on the screen at any point during the live stream, or click the link in the comments below. Now, to break down some more of what's happening in the market across both Australia and New Zealand, we are joined today by Jonathan Mamaril, Director and Head of Employment Law at South Geldard Lawyers. South Geldard Lawyers is a respected Queensland-based law firm with over 60 years of experience, offering comprehensive legal services to individuals and businesses. With offices across central Queensland, the firm provides local insight and a proven track record across various areas of law. Thank you for joining us today, Jonathan. I'd love to ask you a couple of questions of what your take on all of this is. So we'll jump straight into it. So what have you seen as some of the key changes in employment law over the last 12 months in Australia?
Yeah, thanks, Mary. I appreciate that. And thanks for the introduction. There has been quite a few changes. I think a lot of us know about the psychosocial risks and hazards. That is obviously legislation really focused on health and safety, not necessarily from the physical perspective, because we've got a lot of legislation around that, but more around mental health, essentially. Okay. And really, if you break it down, there's quite a few hazards, but if you looked at it, there's really the interpersonal conflict side of things. Then we have really the work itself, like the hazards that are created from the work itself, and then hazards that are created from personal issues or dealing with sort of traumatic events, either that's personal or at work as well. So there's probably you sort of put the hazards into boxes. They're probably the main three boxes. So now starting to see quite a lot of changes in workplaces dealing with that. So now we're starting to see a lot more investigations. We're starting to see a lot more policy development, training. So that area has already started to see an increase in workers' compensation claims in particular. That's probably where it's starting to come in.
Yeah.
Other changes also include, as you said earlier, Mary, sexual harassment. So we have sexual harassment has had quite a lot of change. So traditionally or previously, it was actually a little bit difficult to file a straight out claim in sexual harassment. So what's now happened is there's quite a few avenues to do so. Probably the main one is going to be in, say, something like health and safety or under the Sex Discrimination Act. But there is now obligations, or what we call positive obligations or positive duty obligations, in a roundabout way in regards to psychosocial risks. So that sort of teases that sexual harassment side. We've got increased powers for the Sex Discrimination Commission, who can, in some respects, go into a business and force compliance, okay, whether it's going to be policy development, training, even just dealing with a complaint, actually have an investigation, those simple basic things. Recently, we've also had a change where organizations need to implement a sexual harassment prevention plan. Okay, so that's another step around this positive obligation. And so we are starting to see some changes in the sexual harassment space, especially in regards to complaints and investigations. So we're seeing a big increase there as well.
Right. Which, I mean, in the short term seems like a lot of work, but definitely, contributing to the greater good in the long term. And you've mentioned some of those changes there. And what else do you think employers should do to keep an eye or should keep an eye on really in the coming months in particular?
Probably the one that sort of springs to mind is wage theft. Obviously, there's been big changes in underpayment of wages. So just to make sure that everyone understands, there's always been penalties around underpayment of wages. What now is this takes it to a criminal level. So whatever the equivalent criminal code is in each state will tease that out in terms of a criminal sanction. Which could obviously include prison time. Also, there's just a natural increase in those fines as well. So that's probably the one that sort of springs to mind. The one that has been talked about quite a bit is the restriction on non-compete clauses. Okay, so
yes, I have seen this.
Mary, that's probably going to be legislated. There's already been discussion. Now that the federal election has subsided, we're probably going to see some reform in that space, and that could mean naturally some changes around restraint of trade, restraint of or non-compete around staff members. Will it change in regards to poaching clients and solicitation of, say, other employees? Okay, maybe not, but in terms of movement, freedom of movement, probably that's going to see a change The other one, Mary, is
Interesting.
probably flexible working arrangements. That's probably going to be the other one as well, where you're already starting to see a lot of cases where there's disputes around requests for flexible work arrangement. And, if you think about it, Mary, got work from home, remote work, 2 days a week, all that type of stuff. So we'll see a lot of, we're already starting to see a lot of cases dealing with that.
Absolutely. And it probably will talk to the next point, but what have been some of the biggest challenges for employers within the employment law legislation, and what do you think is the best approach for them?
The employment law space has changed quite a lot. So we've had a lot of legislation, new legislation. I mean, right to disconnect is one, wage theft is another. There's just so many new pieces of legislation. But where we're seeing the biggest change is how the workplace or the workforce is dealing with this. So I think previously there was a huge amount of focus on employee well-being, and there still is. There still definitely is. But maybe that's starting to turn on to compliance, more compliance-based well-being reform and packages. Potentially what we're seeing a lot of is the evolution of the workplace. And what I mean by that, Mary, is offshoring, outsourcing, and technology. And the investment in those three areas, we are starting to see a lot of restructure and redundancy work naturally in that space. So obviously weretention and recruitment is still huge and hot topics for any workplace. They are, but we're starting to see a lot of that restructure work as well, and not just on efficiencies and not just on productivity, but also how will the workplace or the current workforce look like going forward. So for some organizations, that's going to be a different conversation. For others, there's going to be a different again. And that's where these new laws don't quite keep up. So you've got flexible working arrangements are still a little bit behind. Non-compete stuff is still a little bit behind. Even the psychosocial side of things, it doesn't quite handle everything. And so you are starting to see a different way. And even just simple stuff like award coverage, modern award coverage. You have businesses now structured very differently. And so trying to even get that correct, which obviously has payroll issues, and then that has potential wage theft complications. These are sort of issues that all workplaces, that large or small, are having to deal with, and that obviously infiltrates the HR space as well.
Yeah, of course. And naturally, it'd be quite challenging for firms or businesses that don't necessarily have those large, robust HR teams or in-house legal teams. And I guess it's why, you're there to help them navigate through these weird and wonderful challenges that are coming up that have already come through, but also I know there's a few changes coming through later this year as well. So watch this space, I guess. Thank you for those insights. Very handy. We'll shift gears now and bring in our second guest for today. So we've got Gareth Abdinor, who is an employment lawyer and workplace expert at Abdinor Employment Law. So Abdinor Employment Law is a Christchurch-based law firm specialising in employment, workplace and privacy law across New Zealand. Led by Gareth, a seasoned lawyer with extensive experience in both litigation and dispute resolution, the firm provides expert legal guidance on to a diverse range of clients, including organisations and individuals. So thank you for joining us today, Gareth.
Oh, it's my pleasure to be part of this, Mary.
Perfect. And so I'll ask you similar questions to what I did with Jonathan. Obviously, New Zealand is a slightly different market. So what have been some of the key changes in New Zealand employment law over the last 12 months?
Well, Mary, they say constant is the one, change is the one constant that we're always going to have. And I think there has been a lot of change signalled. Some of the changes that have already come into law in New Zealand, like Jonathan was discussing, wage theft, that has become a criminal offence in New Zealand. So any intentional withholding of wages or entitlements by an employer will now constitute a criminal offence, and and that's quite a big change. One of the other things which might seem quite minor, but I think is actually going to cause a lot of issues, is that now it's a legal requirement for all employers to keep a copy of the employee's individual employment agreement and provide that to the employee within 7 days if it's requested. This is one of those things that, in theory, it's always been a requirement to have an employment agreement for employees, but in practice, very few employers seem to have them when they are asked for. And I think they're really going to have to take more care with this. It is a fundamental requirement, and I think it is going to it's going to cause issues because people are going to have to do a bit of housekeeping.
Yeah, I can imagine. Imagine as well for those employees that have probably been with the business for 10, 15 years, where the legislation has changed significantly since that time, even 2 years ago, let alone that far back. So definitely a bit of housekeeping for businesses to go through.
And we get situations where, people have been in the organisation for years and years and years, and their role may have changed 3 or 4 or 5 times, and none of that's been documented. And when it actually comes to the point of documenting that, there can be some tricky conversations.
Yeah, absolutely.
One of the other big changes that has recently been signalled is a change in focus for WorkSafe. Health and safety has really taken up a lot of bandwidth in New Zealand over the past few years, and there has been this perception that a lot of employers have essentially been paralysed through their fear of getting health and safety wrong. The government has directed WorkSafe that they really need to take a different approach now. I've seen some commentators talk about WorkSafe no longer sweating the small stuff. One of the examples of this is they've been directed that they need to provide practical guidance rather than the gold standard Rolls-Royce approach that is really impractical for a lot of businesses. Of course, with any change like this, there are a lot of people criticising it as well. So I suspect we're still going to see the hundreds of road cones everywhere you look, but we'll see what happens.
Yeah, there you go. And it's interesting you mentioned about health and safety. We've definitely started to see that ramp up even here in Victoria specifically. A lot of the clients we work with are now expanding those teams, and it's more than just a function of HR. It's now whole dedicated teams in some cases where we've got anyone from a health and safety administrator to a lead and really having quite robust, a robust function within the business. So, yeah, I wouldn't be surprised if a lot of other businesses kind of follow suit in that perspective.
What I thought was quite interesting when Jonathan was giving his update and talking about the psychosocial risks, certainly from an anecdotal perspective, it seems like the psychosocial stuff in New Zealand has perhaps already had its heyday. We've had a number of years of a lot of focus on sexual harassment, bullying, things like that. And the perception I get now is that WorkSafe is really focusing more on the physical risks in the workplace and moving away from that psychosocial focus. I don't think that means employers should take their eye off the ball, though, but it just shows that there really is a difference between the New Zealand and the Australian workplace.
Yeah, of course. And obviously you've mentioned some of the key changes there. Is there anything upcoming in particular with changes that employers should keep an eye out on?
Yeah. So there have been a large number of changes signalled, and I'll just highlight a few of those. The Holidays Act 2003 is one of those pieces of legislation that it's not a love-hate relationship. I think it's a hate-hate relationship because it's incredibly difficult to use in practice. It's very complicated and it doesn't really fit well with modern workplaces and the types of work that people do these days, it really would fit better in, the 1950s, people working full time, that sort of thing. Now with the flexible workplaces, flexible work arrangements, it's quite difficult to implement. And successive governments have said that they're going to update the Act, and we're still waiting. But we've been told that a new bill will be in place by the end of the year, and that'll be hours-based rather than days or weeks, which will make it far easier to operate. It's supposedly going to streamline calculations of entitlements and potentially allow employees to cash up more than 1 week of annual leave. So we'll see if that actually happens. I hope it does, because the current legislation really is a dog.
Of course.
There's also potentially going to be more certainty for whether a worker is a contractor or an employee.
Okay.
Because at the moment, there are these tricky legal tests that are difficult for employers to actually apply, given that the courts kind of come up with a different answer, and you can go to a different court and, get one answer, appeal it, get a different answer, appeal it, and get a third different answer. So they're looking at introducing a gateway test where if the relationship meets 4 criteria, then the worker will be a contractor. I think in theory, this is going to be a great change. In practice, I think a lot of the time, both businesses and workers want the benefits of contracting without it truly being a contracting arrangement. The worker's not truly in business on their own account. So I think there's going to be some learning required for workers and for businesses.
Absolutely. And when you say contracting there, Gareth, do you mean labour hire as well, or purely people that have their own business entity that are contracting, or is that a whole nother kettle of fish?
Yeah, that's a whole nother can of worms. And I think labour hire is going to be something quite separate. Another big change that has been signalled is bringing in an income threshold for unfair dismissal personal grievances. So people earning more than $180,000 a year will essentially be carved out of the unfair dismissal grievance unless they specifically opt in. And I think that's going to have a whole lot of consequences that perhaps are unexpected. With inflation, I think there are potentially a lot more people earning those sort of wages than people might think, and they're going to be captured by this change. I think that's going to lead to workers being more careful before changing jobs, so that they don't have this lack of security. I think they're going to be negotiating more compensation because they won't be able to use these grievances. And I think they're going to be potentially more arguments over whether the circumstances justify termination or not. So it's going to be an interesting space.
Yeah, absolutely. And looking at, I guess, challenges to date, what would you say are some of the biggest employer challenges with employment legislation, and how can employers approach them?
Yeah, I think one of the biggest ones is this industry has been created where, because employment representation is not restricted to lawyers, we've got this no-win, no-fee industry where claims are made by employees, by advocates who kind of operate on a quantity over quality business model in many cases, and employers know that it's going to be more cost effective to settle the claim than defend it. I think with some of the other changes that have been signalled, including removing compensation for employees who have behaved badly, it's going to level the playing field a little bit more, and it's going to be worth it for employers to actually defend claims rather than just paying a few $1,000s to make it go away.
Yeah, absolutely. And I think with all this change, I think firms will probably work quite closely together with these legislative changes to make sure, there's not a new precedent that's set that, then changes the whole way it all works. So, yeah, we'll watch this space and see how it all plays out.
That's going to be interesting times for sure.
Yeah, absolutely. Well, I'd like to keep you on here and bring Jonathan back, and we can talk on a bit of a more broader view with some of the different perspectives of the market. So going back to you, Jonathan, so obviously both Australia and New Zealand are tightening the employment regulations. How are you seeing businesses balance this compliance and with flexibility and growth?
It has been difficult, if I'm being honest. So talking to a lot of clients, that balance is becoming much more difficult. So no doubt that the new legislation, new obligations, especially things like right to disconnect, has put more pressure on organizations in how they flesh out their workforce and also the workforce planning. There's no doubt about that. I don't think it's the only thing that's played a part, though. So definitely you have external issues such as, cost of living crisis. You still have issues around recruitment, and you still have issues around retention. So I think those things together are playing a part in how organizations look at their workforce and how they plan for the future workforce. That is why, a lot of conversations I'm having, there's a lot more investment in the offshoring, outsourcing technology route. And so because of that, we'll need legislation to cover up on some of those things, because all those areas have legitimate risk that come with that. And so right now, maybe there's a few cases that deal with, say, offshoring. Of course, there's definitely some stuff around outsourcing when it comes to contractors, for example. But we don't have a lot around the technology side. So this is where we're going to have to, and all three of those areas need attention. Yes, organizations have to deal with that, and balancing all those things and those competing priorities, it's a challenge for sure.
Yeah, absolutely. And I think I've definitely noticed it from the recruitment side that a lot more businesses are running quite lean at the moment, but are quite conscious of burning out their staff and knowing with the right to disconnect how challenging that can be. So we've seen an increase in the demand for temp and contractors to help mitigate some of those busier periods and making sure that their staff aren't logging on after hours or weekends, and they've got enough support during those peak times to help them through it. So yeah, it'll be interesting to see. And obviously AI is a big topic at the moment, a lot of automation. So, hopefully that helps, some of those out of hours correspondence and all that. But yeah, and obviously with offshoring completely to other countries and states is also a big thing at the moment. So it'll be interesting. And what about across to New Zealand, Gareth? Is New Zealand looking to reduce the overcompliance as well?
Yeah, I think with our coalition government, they really do want to level the playing field a bit more. There has been this perception that employers have been on the back foot. But I think some of that really is their own fault. Compliance with fundamental stuff like having employment agreements on file, having clear expectations with their workers. Some of those things really have been lacking. I guess it's not surprising, New Zealand's employment market, we have a lot of small and medium businesses. Employment law can be really tricky, and so it's difficult staying on top of that. But I think it's going to be a need to focus on what's important. Otherwise, businesses are going to be running unacceptable risks.
Yeah, absolutely. And obviously with personal grievance reform in New Zealand and the psychosocial risk requirements in Australia, they do point to greater employer accountability. So how should leadership teams evolve in response to this? Either one of you.
Well, I think from my perspective, there's nothing that makes employers and boards pay more attention than when things start to cost money. And certainly with some of the decisions coming out, there have been some pretty hefty remedies awarded to employees. And I think they're going to start paying attention to that. They're going to have to start paying attention to that. When you have to put that in your financial accounts that you've paid, tens of thousands or hundreds of thousands, that's your way of being accountable.
Yeah, absolutely. And what about for you, Jonathan?
From the Australian perspective, there's a couple of ways to look at that and answer that question. I think the first one is, looking from a board perspective and from the executive perspective, there are your fundamental risks. So one is, for example, general protections and adverse action. That's how they can peer through, and they can an employee can sue someone personally. Okay, so you can attach that vicarious liability. But there's, obviously wage theft as well plays a part as well. So there's some avenues. Health and safety, another one, has avenues. But there's also been quite a few, let's say, brand names who have been involved in some big incidents.
Yeah.
So sexual harassment and health and safety are probably the big ones, and underpayment of wages. Sorry, they're probably the three big ones. And the PR that comes out of that, the public relations that comes out of that is very negative. Right now, I'm not a branding expert. I don't know what that actually means, but I suspect it's probably not great. And so that definitely plays a part in terms of not just the cost of that risk, yes, the personal costs and costs for the business, but I think that the PR side. Now, I think that plays a little bit into that whole idea of we want to be the employer of choice. That whole idea of we want to be the employer of choice, and we attract the best talent, all those types. I think that plays a part. And I think the other part that it plays is, like, how does that look to the audience, our target market, our clients, and I think that the branding side of things as well. So especially with social media being so prevalent now when it comes to brands. So I think that's probably what's keeping organizations accountable. Yes, there's the legal side for sure, which is a stick. But and I suppose there's some carrots, but it's really a stick. But I think the biggest stick is actually more that PR side, the public relations side, which probably plays a maybe even larger role.
Yeah, absolutely. And I think you're so right. Social media is a big tool and stream for information these days, that any grievance or issue someone's had with a particular brand or workplace, it's on socials quite quickly, and that can spread like wildfire. So businesses should either be equipped with the right resources and training to deal with these situations, or just ask for advice if they're not sure before it kind of gets to that point as well. So which brings me on to my next point. So AI is now influencing legal and HR workflows quite a bit. So what do you see as being the most practical application for organizations to use, the most practical applications in general for organizations to use in the next 12 to 24 months?
You can definitely answer this one first, Gareth. Well, I
think it's undeniable that businesses and workers are using AI, and it's almost like a tsunami that you can't stop. But what I have seen is that there seems to be a lack of sophistication and a lack of checking some fundamental things before these applications are used. The biggest concern that I've seen so far is that a lot of the time the results provided by AI are just incorrect. I've had a number of clients try and do the first cut of something using AI, and almost inevitably it hasn't been legally correct. And so I can see individuals and organizations getting into a lot of strife because they get led down the wrong path by AI, either because it's made something up or it is referred to something that's no longer current law. And one of the other big issues is that people are using these AI tools without thinking about the confidentiality and privacy aspects. And certainly the New Zealand Privacy Commissioner has released some guidance, but I see people all the time using these applications, putting in sensitive information, putting in confidential client information without realising, where's that information going? Where are these AI tools based? Do they comply with New Zealand privacy laws? And do the customers, consumers, clients know that the organisations are using AI tools and are putting that customer information into them? And often the answer is no, they haven't even thought of that.
Yeah, absolutely. And I think it's more, I guess, how employers could use them on a more practical level is probably get that first line of maybe, okay, this is the steps you should take. It's not, don't take the advice as gospel. You shouldn't be, it's giving you a 10-step on how to manage performance or a psychosocial risk, but it should, I think, at least empower people to know where to go next, whether that's speak to an employment lawyer, look at legislation.
In a way, it's almost like a more sophisticated Google search, for years and years, as a first step, as a first cut, what do? We do a Google search, we see what the net comes up. AI is like a more sophisticated version of that. I think where it's really dangerous is where people put more trust in it than that. It really depends on the information you put in. And it depends on the search terms you use as to what you get back.
Interesting. And Jonathan, what are your thoughts?
I understand Gareth's points on that. I probably come at it from a different angle in that. I understand. Look, firstly, it's here, right? So I think anyone that sort of says it's not here, it's here. I think we've got to accept that the law has not caught up with like any law. Pick any law, really. But employment law in particular has not caught up at all with the use of AI and how it's going to be utilized. I mean, you see applications, unfair dismissal applications, any application, any dispute, just a complaint. You can see that's done by AI. Some it's wrong, some it's okay, some it's right. It's it's a hit and miss. I think Gareth's right in terms of the over-reliance upon it. For sure. Like I think there is probably a bit paid too much heed that it is that reliant. I think it's also not paid enough attention that it's actually probably better than it actually is. Where I think it intersects in particular in the HR space is potentially your basic work. Okay. So your basic documentation and then sort of improving upon that. Potentially, I think there's a bit of go there. Obviously, if we talk about AI as well, you're talking about automation. So automation definitely, I think players will play a huge part. But a question that I really have, which is, and I think there's been a lot of people who talk about AI, and it has been mentioned quite a bit. The evolution of the workforce, like that, the interesting part to me is what will that look like? We're just sort of touching that, but the evolution of technology, even in the last couple of years, has been immense. Look, do I watch AI videos? I get a weird feeling still, like it's weird. Right? It looks weird. People telling you that it's awesome. It's not awesome. It's weird, right? But eventually, it's creepy, right? It's creepy. I don't know what it is. We all know it's creepy. But that will evolve. That will change. I think we all understand that will change and evolve. But the more interesting question is, so when that starts to happen, when that starts to get to that point of, excellence or very good or even good, what happens then? And I think that's more the key question. Right now, you sort of can differentiate it. That's rubbish. That's not very good. I think the real question is what happens when it becomes good. And then, of course, we start talking about more high level stuff, which is that sort of displacement of people, the training of people. What does that look like? Right now, it's probably going to be things like how do we train our managers, our staff, our teams on how to manage people in the context of this technology, especially in organizations where maybe technology wasn't utilized a lot, and especially in organizations, parameters around those who use technology a lot. So I think that the two extremes, that's where you're probably going to get a lot of bang for buck. People in the middle right now, that's a bit up in the air. So I understand the points that Gareth's making, and I think they're all valid points. I think the more interesting conversation really is going to be when it gets that level of good, let's say, or even average to good, when those videos you see and you go, actually, not sure. That's when I think the conversation changes. But I think we need to we need to already be up in front of that. And the law, unfortunately, in any type of law, and I suspect it's the same in New Zealand, it's gonna take some time to catch up. The time to do that is now. We need to look at that now. You're already starting to see cases where you've got people who put in just the wrong application, wrong cases. Judges are figuring out how to deal with that now. But if you look at some of the initial ones, no one knew really how to deal with that. Like, how do we, this is just completely wrong, So I think that's going to be the more interesting conversation going forward.
Yeah, absolutely. And I know, I'm sure it's happening in New Zealand as well. I know there's some law firms that are now building their own AI tools from a legal perspective on, okay, how can lawyers navigate certain cases and using AI to help them progress cases and get some kind of fundamentals down. And I think if you can have that then for in-house businesses and have them part of the HR toolkit, and where employers or managers can go to these internally built AI tools and ask them how to manage certain work situations, it could be quite helpful. But again, that then relies on the legislation being updated correctly and all that information in the back end to be regulated internally and make sure it is spitting out then the right advice, I guess. So,
Mary, can I just jump in on that point? I think because it's a really good point. I think right now there's a bit of an analogy. That analogy is currently, let's say, HR software. Think of any HR software that's been implemented by any HR team, payroll, anything, HRS system, anything. The obligations and responsibilities right now do not lie with the software company. They say, we are a software company. We just provide the software, right? And it's up to the employer is responsible. So if there's an underpayment, and we've tried already. We've had this many times. I'm not sure in New Zealand, but in Australia, we've tried many times. Not we, but it's in our country has tried many times. Is the software company responsible? And it's come back many times from the court saying no, the software company is not responsible, right? No matter what the salesperson tells you, right? But it says no, not responsible, right? So means it's up to still the employer, and we have a difficult, complex award system, enterprise agreements, all those, all complex, right? So it's all down to the employer. So we have sort of an analogy, right? Something analogous that we can work off, which is essentially coming back down to, if you ask back to that question you said, the responsibility will still lie with the employer. Then that then comes down to, well, then who's going to be responsible for that? That is going to be the point where, and right now it's probably HR, it's payroll, but they're going to accept that obligation, accept the liability. If they're going to do that, there needs to be training. There's, all these things need to be in place. And so that is going to be we already have a sort of analogy. I don't know if that adds to the conversation.
Gosh, you'd have to be.
I think that's a fantastic analogy. I think it's really good. I talked about the Holidays Act and how difficult it is to implement, and a lot of the payroll providers and payroll programs in New Zealand didn't comply with the Holidays Act, and employers were paying their money for this product, thinking it complied, believing it complied, and it didn't. And I think that's a great analogy, because ultimately the employer is going to be responsible when it all goes wrong.
Yeah.
I think the other interesting point about AI, though, is that once AI gets good enough to take over all of those routine HR tasks, the real value is going to be in those authentic human relationships. And, we're talking about employment, we're talking about people. And once AI takes over a lot of that processing admin side of things, I'm hopeful that that'll give people working in this space more time to actually focus on the important human stuff. Which, let's see if that happens.
Yeah, I know. Watch this space. Well, speaking on the employee side of things, so employee rights, anything from contractor status to harassment protections are expanding. Are we moving toward a more litigious environment or one with clearer boundaries? What are your thoughts, Jonathan? I'll start with you.
I'll start with this one. Because you took the AI stuff, Gareth. So I'll take this one. Look. I think in terms of more litigious, the answer is naturally yes. We are, and what I mean by that is the laws that we have in place, and I'll probably look at going forward. There's going to be potentially changes around the clerk's award with work from home criteria. You're going to have potential changes around even the work week, penalty rates there might be enforcement of penalty rates legislated. So there are going to be these changes. If you look at how this is working out so far, the intentions might, and I think you can see the intentions of the government, but it is naturally flowing down to, complaints, applications, and ultimately litigious proceedings. The idea is to encourage and, to be honest, legislate that employers be positive in terms of having positive duties or proactive in their obligations. And that's great. But the problem you have with that is if they fail with that, because you've legislated that, then naturally there is an error and there's a mistake. And so that's the problem you have with those types of legislation, which we're seeing a lot more have those types of obligations as opposed to a more reactionary situation. So yes, that's a long way of saying I think there is going to be more complaints, more of those things, which eventually lead to more litigious proceedings.
Yeah, there you go. And what about for New Zealand? Would you say New Zealand is expanding or is going the other way with employers' rights being restrained?
Well, I think certainly there's a change in emphasis from the employer is always wrong to sometimes the employee is wrong. But I think, just like Jonathan said, that's going to lead to as much or more litigation because it's going to move the argument. So, for example, if there's no compensation where the employee has been guilty of serious misconduct, I suspect there's going to be more disputes over what constitutes serious misconduct and what doesn't. Like the proposed income threshold for unfair dismissal claims, then there will be more claims for discrimination or disadvantage as opposed to dismissal. So I don't think Jonathan nor I are likely to be lacking in work anytime soon. I think the argument's just going to move.
Yeah, absolutely. Well, good news for you guys, I guess. But looking ahead, what single regulatory shift do you think will have the biggest impact on workforce planning in 2026?
I mean, from my perspective, I think they're two, and they're both equally important. On the one hand, employers are going to have to up their game. They're going to have to up their compliance with keeping the appropriate documentation that they have to have, etc. But on the other hand, I think employees who have managed to take advantage of what may be a slightly unfair playing field, they're going to have difficulty, because if you've behaved badly as an employee, you're no longer going to be able to pursue a claim and rely on the fact that the employer is just going to throw money at it to make it go away.
Yeah, absolutely. And Jonathan, what are your thoughts?
Probably flexible working arrangements.
Yeah.
That's probably going to be any way you want to take that. So whether it's working from home, remote work, all those types of things, I think that's probably going to make the biggest change. So whatever that criteria or whatever the restrictions are around that, and it could be even industry specific changes, whatever that is, I think will probably have the biggest hit on workforce planning, which in turn probably will lead to investment in other areas. The other issue is still going to be recruitment and retention. I still think it's still a big issue. Those are still going to be the biggest issues. And as you probably know, Mary, like there's certain industries that are crying out for people with particular skills. So that expansion into, what does that look like if we just can't get the skills in or the people that we want? What do we do? And the legitimate questions.
Yeah, definitely a big one that we're seeing at the moment. A lot of people shifting gears, moving industries, and everyone's thinking about, well, we're in this pocket now where we need certain skill sets. But if it's we're talking about employment law, particularly being a lot more litigated, where do you find those people? Where do you find employment lawyers that have had that extensive litigation experience if it's a relatively new shift into the market in general? So it'll be interesting to see how it shifts. But I think, there's obviously the opportunity for a lot more automation and offshoring, outsourcing, which I think will make everyone's life a little bit easier. But I just wanted to say a big thank you to both of you for your time today. Your insights have been very handy, and you've given us some great insights into your respective markets as well. So anyone that is watching and would like to reach out, there's Jonathan and Gareth's details below, and I'm sure we will hear from you both again very soon.
Thank you.
Thank you very much. Thanks, Mary.
No worries. Perfect. And just a reminder, for all the insights shared today are based off our 2025 Employment and Salary Trends Report. If you'd like to have a deeper dive into salaries, benefits, and workplace trends across your market, you can request a copy by scanning the QR code on the screen now or by clicking the link in the comments below. Lastly, whether you're looking to grow your career or build your team with the right talent, the People to People Group can help. As an award-winning recruitment agency, we operate across Australia, the United Kingdom, and with specialists in the market within every major market. Across the ditch in New Zealand, we've proudly recruited for over 23 years through Frog Recruitment, with offices in both Auckland and Wellington. And in South Australia, Edge Recruitment and Adelaide's leading specialists in property, real estate, and general admin roles. Contact details are on screen now, so use the link in the comments to reach out today. And that's all from me today. So thank you very much for joining the Employment Law Update, and I look forward to seeing you soon.